Yes, who's going first?
Well, Lord, good morning. My name's Tom Cosgrove. I'm going first. I'm here on behalf of Mid Suffolk District Council with my learned junior, Ms Parek, who sits behind me. Learned friend Mr Tucker appears on behalf of Bloor Homes, and learned friend Mr Lewis appears on behalf of the Parish Council. Lord, shall I kick off by just checking that you've got all the correct documentation? I'm sure you have.
Yes, well, we've got three bundles. We've got a core bundle, supplementary and authorities.
Indeed.
I can tell you that we have read the skeleton arguments, we've read the judge's judgment, we've read the officer's report, and we have read the record of the debate that took place at the council meeting.
Have you had a chance
to committee meeting?
Have you had a chance to look at the neighbourhood plan?
Yes.
Great, thank you very much. Well, I will go as speedily, as efficiently as I can with that in mind. Look, I did notice, Mr Council, you haven't actually got anywhere in your bundles a copy of the NPPF.
No, I noticed that.
I've taken the liberty of copying paras 11 and 14.
Yeah.
Can I pass those up? My learned friends have copies of them.
Yes.
A bit of an error on our part, not included. Yes. So if I have those passed up to you, if I may. So, my Lord, as you know, the appeal is from the order of Mr Timothy Mould KC, sitting as a Deputy High Court Judge, dated the 21st of February 22. Judicial review claims, my Lord knows, concerning the grant of an outline planning permission, as my Lord's read already. Permission was granted by you, my Lord, on the 19th of May of this year. Planning permission issue granted as long ago as December 2020, and the application that led to that grant was considered by the Planning Referrals Committee of the Council on the 29th of January 2020. That interim was the making of the 106, or the matters that go on before the grant. Lord, you've had an opportunity to read much of the documentation, for which I'm grateful. Can I just start by giving an overview, I hope briefly, of our case?
Yes.
In our submission, this sequence of events and the determination by the Council is a classic example of a planning committee grappling with and applying, and I emphasise the word applying a number of development plan policies and material considerations in a particular context which was informed by the up-to-date evidence, in particular of housing need, as it then existed, and then forming a planning judgment as to whether permission should be granted. And Lord, just at the outset, in my submission, it is perhaps easy to forget that when one's looking at the detail of the submissions in this case, that the detail of whether, what we're really concerned and what the submissions are about is whether a particular part of a single policy in part of the development plan was construed correctly or not.
Well, there are three possibilities, it seems to me, speaking for myself. One is that there is no conflict between what the committee decided and the neighbourhood plan read as a whole. Second is that the housing policies in the neighbourhood plan are out of date, with the consequence that the tilted balance applies. And the third possibility is there is a conflict, but other material considerations lead to the decision that was in fact taken.
Yes, and Lord, what the committee, following the recommendation of the officers, one of those cases where the committee followed the officers' reports, they're interchangeable, found that looking at the development plan as a whole, with the constituent parts of it, of course, one of which was the neighbourhood plan, concluded quite clearly that there was a conflict with the development plan as a whole, as a matter of judgment. Now, within that overall judgment, there were many policies which they found compliance with, and that came into their balance, but the key policies, I'll come to in a moment, which were out of date, which dealt with development in the countryside and the fairly vintage core strategy and local plan, were plainly conflicted with by the proposal. No issue with that. So this is one of those cases where the structure of the overall decision was conflict with the development plan as a whole, material considerations nevertheless justifying the grant of permission. And that is the key part, really, which was what I was... It is easy to forget that is the important structure. Within that structure, what we're really arguing about in this case, and I'm going to come on to suggest that really it's an argument we shouldn't be having, because this is really a common sense application of policy. But what we seem to be arguing about in this case is whether a particular part of a particular policy within that development plan, policy 1 in the neighbourhood plan, was construed correctly or not. And the officers reported on that issue, and the members accepted. As I say, there would be a conflict with the plan as a whole, but weighed then carefully, we say, the material considerations in the balance, in finding that the proposal was a sustainable one, and one that would obviously deliver much needed homes and infrastructure for Thurston. So, just by way of overview, it is in my submission an exemplary, and I put it as highly as that, an exemplary application, in fact, of the section 38.6 duty, which is the overarching duty that applies in these kind of cases.
Well, what about what the Chief Planning Officer said during the meeting?
Indeed. On the particular issue, the issue in this appeal, which relates to that, he was quite clear that there was no conflict with the neighbourhood plan. And I think in relation to, I think there were 9 relevant policies flagged up. I don't think there's any issue that most of them were complied with. In fact, the benefit, the issue was just a one sub-part of policy 1. And his advice was that there isn't a conflict, there was a tension with it. And in essence, we say that that is a perfectly lawful application of a policy. The word focused was the key matter. Rather is in the Wyatt case that learned law helpfully provided us with before, focus just as adjacent was the word and issue in that case. Focus is not defined in the plan, and it is in my submission the kind of word that planners should be left to apply their judgment to. We say, by way of overview, that when you have a policy such as that policy, which requires new housing development to be focused within the settlement area, that does not preclude, obviously, some development taking place outside of the settlement area. Policy could have said there shall be no development, as many policies do outside of the settlement area. Requires a focus. Whether something looked at in context, and that context will require a consideration of what other development has been allowed, what exists, what's coming forward, whether that is a focus looked at individually is a matter in my submission or planning judgment, which the officers in this case undertook. The members accepted, and their judgment was that there would not be a conflict in this case, because allowing this proposal outside the settlement boundary would still be in accordance with the focus viewed in context of new housing going in the settlement boundary. And I'll come on and develop that point. But in essence, our submission is that this really should be a case where, with respect, the court is saying, well, that's really a matter of planning judgment, and the court's, unless it's entirely irrational, obviously, rather than construing focus. In essence, my submission, I don't think anyone is really saying that focus means you have to have absolutely everything inside the settlement boundary. At least I haven't discerned that from the learned friend's argument. And indeed, the learned judge below, we say, in a sense, was with great respect, too sort of legalistic and construed it rather like a statute or contract, rather than allowing the judgment element of construction, which we say the courts have indicated the planning officer should be given leeway to do, rather than construe it like a statute or contract, in his judgment.
Yes, well, I mean, he thought that the policy erected what he called a barrier.
Yes, indeed, absolutely, a barrier to other development outside. And we say that's not the correct construction, although, as I say, I hesitate. I think the correct construction is focus is not defined. It's a matter of planning judgment how you apply that policy within the bounds of rationality. And that's exactly what the officers did in this case. So that's the overview. Lord, the way I'm going to propose to structure my submissions, if I may, and I will go with as much pace given the helpful indication of your reading. I wanted to cover a few factual matters by way of relevant context, the emphasis on context, as you know, from the case law and how it construes. And there are 7 sub-areas, but without terrifying the court, I'm going to go through them pretty quickly. Then I would like to deal, I think, again, very briefly with some relevant legal principles, and then finally address the grounds of appeal. And I hope by that stage I can be very brief indeed, because I will have covered a lot of the ground as I go along. Lord, can I just deal first of all with the factual context? The site, as my lord will have seen, and I'm going to not take more to too many page references unless you feel you would like to look at them, because I'm conscious you have seen the relevant documents. The development site, as you will have observed, lies to the southwest of Baker Road and Thurston in Mid Suffolk. It is located within the council's district, with the exception, as it happens, with some proposed highway works you may have read about to Fishwick Corner. They were actually in a neighbouring. It falls, therefore, just outside the settlement boundary as it now exists, as defined by the neighbourhood plan, but within the parish of Thurston. And that is perhaps of some importance when one looks at the neighbourhood plan in due course. So far as the development plan is concerned, my lord, in the officer report at core bundle 8, you will have seen that set out on page 209 in the bundle, which is 3.1 in the report. There's a useful summary of what the development plan then constituted. That's page 200.
Yeah.
And in essence, it constituted the Mid Suffolk core strategy, the Mid Suffolk local plan, the focus review core strategy, and the Thurston neighbourhood plan. The neighbourhood plan, with which this case has so far been principally concerned, was adopted in 2019, and as I say, it is important to note it covered the period right through to 2036. I'm going to come back to that point, but my submission isn't another important contextual point. Lord, on page 159 within the officer report, and I'm using obviously the numbering in the bundle rather than the rather confusing numbering you see just above it in the report. So 159 of the core bundle within tab 8. The report advised that there were a number of policies of, as it put it, of particular relevance. And it listed, you will see at the top of that page, some 9 policies within the neighbourhood plan. And then turned below that to the other relevant parts of the development plan and the core strategy and the core strategy focus review, and came to the judgment that the most important policies viewed in the round were CS1, CS2 from the core strategy, and H7 in the local plan, and put forward again the judgment that they were out of date by virtue of being inconsistent with the NPPF, so that the tilted balance in paragraph 11, as it's known, colloquially in the planning world, was brought into play as a material planning consideration. Now, Lord, I can take you, if you would like, to the text of those policies CS1, CS2 and HS7. They're found in tab 15. Would that be helpful?
You must do as you please.
I'll do it. Well, I will very briefly, just if I may, then take you to tab 15 in this bundle. Forgive me, sorry, it's
and these are the core strategy.
These are 2 of them are the core strategy, 1 of them is the local plan, and these are the suite of policies which really deal with development outside of settlement boundaries. So, if my lord looks at page 334, just by way of context, you will see there's some text there, part of the development plan, which deals with settlement hierarchy halfway down the page. And you will see in paragraph 2.28, there's reference to, in the penultimate couple of lines, to some villages being referred to as, quote, key service centres. And those are deemed to be settlements, of which Thurston was one, that have the potential to accommodate development which is sympathetic to local character and of an appropriate scale and nature in relation to local housing. And then over the page, you will see, again, reference at the top to key service centres as being places where as the main focus for developments outside of the towns. So in the settlement hierarchy, Thurston was a village, but it was a key service centre. The actual policy, CS1, dealing with settlement hierarchies over the page on page 336, obviously read in together with the text. And you'll see within policy CS1, about halfway down under the...
Sorry, where are you now?
So I'm so sorry, page 336, just the following page over, policy CS1. And then you'll see in the middle tabulation, key service centres, you'll see Thurston on the right-hand side, and ultimate. So that's, as it were, the structure. And then just to finish the suite, you will see that if one goes over the 2 pages on to page 338, CS2, which is the other policy mentioned in the report at this stage, that's the policy dealing with development in the countryside. So by definition, the way this development plan worked, if you're not within the settlement boundary, you're in the countryside. And you will see that development in the countryside is restricted, save for a series of defined categories, of which this proposal did not fall within. And then finally, just to as it were, finish this point, that we've concluded H7, which is from the local plan, another part of the development plan.
Sorry, page which?
The next page on, was 339.
339.
The final page, I think, in the bundle. And that is the development headed restricting housing development in the countryside. And in essence, it provides for standard of strict control over proposals for new housing in the countryside. So the simple point from that suite of extant development plan policies is if you're not in a settlement boundary, you're in the countryside, there's a very strict presumption you're not going to get any permission. Those were the relevant policies which existed, to be read of course in tandem with other parts of the development plan so far as were relevant, which the officers concluded were out of date. They'd been looked at, as you will have seen in the report, by several planning inspectors. And that would have been principally because of the up-to-date need for housing need, which is evidence-based and reviewed regularly. And so it's because of that, and in light of the NPPF, the officers considered, they took the judgment they were the most important policies, they were out of date so that the tilted balance applied. That was the overall structure of the officers reporting to members. Next on the subject was the emerging plan which existed at that stage. And Lord, of course, as you know, the emerging local plan that then existed would not have constituted part of the development plan, but at that time would have constituted a material planning consideration for the decision maker. And can I take you in that regard to call bundle tab 13, beginning on page 328 of your bundle. And what you have beginning on page 328 and over the following few pages is an extract from the then consultation draft that existed of what was emerging as the hoped-to-be local plan. And at the time of the resolution to grant planning permission in January of 2020, my lord goes to page 329, you will see a reference to a site allocation LA 087, land south of Bacon Road, Thurston. So and the development site was almost identical. There's a slight nuance actually in terms of the land, but it's pretty much the development proposed site is the same as that area.
Yeah, that's what the officer quotes at page 159.
Indeed, in the report. And you'll see, just to orientate you, if you go 2 pages further on, you'll see that there's a little map, and you'll see that that LA087 is to the south of Thurston. That's pretty much identical to the proposed appeal site. So you will have seen that, as it happened as part of the context at that time, within the emerging draft local plan, it was a site allocation proposed for approximately 200 dwellings, so very similar to what was being proposed by way of the planning application. And as the committee report made clear, as the court will have seen, that was considered to be and reported as a material planning consideration. And while it was said by officers, again as a matter of planning judgment, it should only be afforded, as they put it, limited weight at that stage. Nevertheless, they reported to members that it, quote, provided an indication of the intended direction of travel in relation to where sustainable development should be located. I don't take you to that, but for my lord's note, that's page 159 of the bundle in the report. The next part of context I would just wish to focus on is, you will have seen reference to what are known in the report as the Thurston 5. And that refers to 5 developments which had been granted planning permission by the council in 2017. Those grants of permission all predated the adoption or the making of the neighbourhood plan in October 2019. And Lord, if I can take you within tab 7 to page 149.
Sorry, could you give me the page again?
What, 149, lady?
Thank you very much.
And so we're within here the neighbourhood plan itself, and this is one of the figures at the end of the neighbourhood plan. Figure 13 is the one I'm after. And you will see on that, so although the appeal site, you will, I think you're familiar with, is down the bottom but not marked, I think you know where that is now. The first and 5 are those highlighted in the top, A, B, C, D, and E. And they're all within the extended settlement boundary as extended by the neighbourhood plan, deliberately. The neighbourhood plan extended the settlement boundary to include them specifically. So they all existed already, But as I'll submit to you,
Can I just ask
Sure,
you,
yes.
could those developments proceed effectively without the highway improvements which are associated with the current planning application?
they could proceed. In fact, I took instructions. 4 of them are currently being built out.
Right.
So yes is the answer. It still remains the position. My instructions are that the highway issues which you will have read about need to be resolved, and there's a certain urgency. But in a sense, there's nothing one can do to stop the developers of building them out once you've got planning permission. But the highways issues are still live. So I'll come on to. But as a fact, yes, they can proceed, and in fact are. 4 of them at least are being built out. And also, as I'll come to, but just to flag up at the moment, what the neighbourhood plan did was to leave future housing need, and by that I mean housing need within the period to 2036, which was as it were, the end date for the neighbourhood plan. It left that specifically, and the issue of further locations for housing in the parish to the emerging joint plan. And I'll come to give you the textual references to the neighbourhood plan where it's explicit about that. Now, as a result, in our submission, and you will have seen this grappled with in the earlier submissions, we say it did not contain any policies within the neighbourhood plan to meet its full housing requirements as they then existed to 2036. And it did that deliberately because it knew some other plan was coming forward which would deal with that. It could, and I'll give the textual references in due course, but in my opinion, it is important to note at this stage that to that extent, beyond identifying that there were already 5 permissions and extending the boundary to cover them, it did not as a plan make any attempt to identify its housing need, as it could have done. And other neighbourhood plans could instruct people to look at housing need, what do we need to 2036, and let's do it. It didn't do that, it didn't have to, but as a consequence, I say that is relevant when one looks at
I think the
context.
judge accepted that, didn't he? I
He did accept that.
The thrust of what he decided was, put it colloquially, you've jumped the gun.
Yes, I think
You should have waited until the emerging plan became statutorily adopted.
Yes, and he did, and with great respect to the judge, with great respect, I don't think that reflects the reality of on-the-ground planning. I mean, the officers had to grapple with need, which is a fast-moving topic, but they had an evidence base of need. They had a plan in the neighbourhood plan which purported to deal with matters until 2036. Now, I think Lord below in the High Court put forward the proposition, I think just to my learned friend making his submission at that stage, that well, there could be a review of the neighbourhood plan. Yes, there could be, but there might not be. And what we're dealing with and what the officers were dealing with was a plan that was relatively newly made that purported to deal with matters up until 2036. And it was on that basis that they construed and applied it. Now, Lord, the next little subject, if I may, leads on to that, which is the housing requirement issue. Another material consideration put to the members by the officers and noted as a material planning consideration was that the up-to-date identified in evidence minimum housing requirement for Thurston during that period to 2036 was 1,468 dwellings. And Lord, the reference to that again you will have seen in the officer report, page 217 within tab 8. I could invite you to look at that.
Is that a need throughout the area of the district council?
No, that is the need just for Thurston.
Right.
And I'll give my lord the reference just to pin that point down. So if my lord goes to page 217, you will see what the officers are doing at that stage. There's the table in the middle of the page, which is effectively the Thurston 5. And they've set out how many, so you can see the Thurston 5 varied from being a couple of hundred each, so there's probably about 600 or 700 houses.
It's 3.8.2.
Indeed, yeah. Exactly. So it's the upshot of it is this, as the report says, going over to the page 218 as well, that even when one accounts for the Thurston 5, the up-to-date evidence indicated that the shortfall just for Thurston in the period to 2036 equated to some 650 dwellings. So to put it another way, the officers took the view as a matter of judgment that the neighbourhood plan given that it chose expressly not to allocate any further sites or look at its need to 2036, had only, on the face of it, identified enough sites for around 55% of its identified need. That's the way the officers put it to members. And this is the part of the report where they were.
Who has identified that as being the need?
That is the evidence base that will be prepared by consultants. As it happened at that stage, it was part of the evidence base for the emerging local plan. So as my lord knows, when these local plans are being prepared, various consultants are instructed. There are specialist housing needs. Sometimes they're in-house, more often they're external consultants who prepare an evidence base.
I suppose what I'm asking really is, does Thurston accept that that is its need, or is that the view of the district council?
That's the view of the district council. I mean, in effect, the neighbourhood plan, if one puts it that way, the makers of the neighbourhood plan, as I said, chose not to get involved in that. They could have done, incidentally. There's nothing to stop a neighbourhood plan saying we're going to. Practically, it's often not something they would wish to spend money on, but some do. And some neighbourhood plans do allocate sites to meet an identified need as they see it. It is the nature of planning, as my lord knows, that the housing need is A, very political, and B, very fast-moving. And it depends on government figures, a lot of its inputs, which change sometimes from month to month. But in the planning world, one has to work with what one has at the time. And at this stage, there was a well-prepared, as the officers saw it, evidence base which was informing the emerging local plan, which had gone into detail and, as it happened, for present purposes, identified for Thurston, along with other key centres, the need as they saw it then to 2036. So, and it plainly was, and I don't think there's any disputing, it plainly was a material consideration for members. What they did with that evidence and how much weight they gave it was obviously a matter of judgment for them. So that's the... And I should just pick up on one point, because you will have seen on page 218, 38.8.4, there's reference then in the officer's report to this difference. And they say in 3.8.4, the difference between the housing requirement in it for Thurston and that now in the adopted neighbourhood plan draws attention to a serious conflict of approach. The conflict of approach is really just that what the officers were meaning by that was, well, the neighbourhood plan had chosen not as an approach to identify housing need, but the emerging local plan had. And so you've got the neighbourhood plan, which is in a sense saying, well, we've got the Thurston 5 and we're not going to allocate any more, whereas the joint local plan as emerging was identifying what was needed. And Lord, as you'll see in a minute, as officers went on to make clear in their report, once their view was accepted by members, once that context underlying the neighbourhood plan is understood, in other words, the neighbourhood plan accepts that other housing may be needed for Thurston, so I'll come on to see, and it also accepts that it hasn't sought itself to grapple with that need for whatever reason. In that context, along with other matters, it is entirely appropriate to find, as it were, a lack of conflict with a neighbourhood plan policy in issue when you read it in that context. I'll come on to develop that point. The final or penultimate matter of context actually relates to highways issues, which I mentioned earlier on. Again, in this case, in terms of further material planning considerations, the report set out in particular a raft of highway improvements that were to be secured as part of the development by way of a 106 agreement, section 106 agreement. And Lord, if you look at page 228, and my Lord Justice Singh, I suspect underlying the question was that you put to me a moment ago was the importance given to these, because they are put in on a very high level, rightly so. Page 228, if I just take you first of all on that page to 3.12.1, this is the end of a section dealing with the principle of use, and you'll see in the various bullet points that the officers were suggesting that led to part of the reason for the acceptability of this proposal. There are a number of benefits, including, if one goes 4 bullet points down, it delivering a raft of highway improvements required in the Thurston neighbourhood plan. And then what happens then over the next few pages is a detailed discussion of the particular impacts and the improvements. They are usefully, I think, summarised on page 233, paragraph 3.16, under the heading, which is a question, So what main improvements are included in the application? And there are 13. There are 13 then listed. And importantly, preceding that list on 316, and the paragraph actually just begins at the bottom of the previous page, but the essence of the paragraph above 316 is relating to policy 7 in the neighbourhood plan, and makes the point that by this application, by identifying solutions to problems with Bloor Homes, has one big advantage over the applicants associated with the Thurston 5, and that is that their ownership and control of land outside the public highway necessary to design and implement meaningful improvements. No other applicant could achieve this in terms of all 4 of the locations identified above, and that includes the county council as the local highway authority. So it was seen as a very important aspect that this proposal could deliver. Final reference I'll take my lords to is page 235 in relation to highways, and you will see it's summarised succinctly at 3.17.3, where officers report that one of the main public benefits associated with this development is the raft of much needed highway improvements, particularly to the south of the village and the railway line. If members are persuaded that these benefits, along with others, outweigh any associated harm, and this is the view of officers, then it is imperative that the village sees the provision of these improvements at an early stage and not some elusive point in the future. This is a must. So,
as I understand it, is this right? These are not highway improvements which are simply necessitated by this particular development. These are, the officer is saying, a need in this area anyway.
yes, they fall into that category of being, many of them, necessary for the development, but having benefits which will help other developments as well. Because obviously, to be in the 106, by definition, they needed to have a nexus with the planning proposals. They needed to be necessary. But but they, as it happened, they had benefits to the other developments because the accesses were shared, particularly in relation to going under the railway line and the bridge and the footpaths. They straddled both matters. So, but there's no question the Learned Friends clients had very much the needs of Thurston in mind and tailored their application to meet those kinds of points as a benefit they could put forward. And for present purposes, that was something, as we'll see, was particularly flagged up in policy 7 of the neighbourhood plan, which this proposal plainly complied with and was seen as a very important consideration. Although finally, just by way of context and background, the office report, much of which I've traversed already, and I know you've read, but in our submission, the report, read as a whole, is plainly comprehensive, whatever one thinks of it. It's a comprehensive assessment of the proposal. It plainly concluded a detailed analysis of the relevant policy context, as well as dealing in detail with the responses and representations that have been received by the council, including from my learned friend who acts with
Could it be said that it's a bit mealy-mouthed because it doesn't directly grapple with the question whether there's a conflict or not? I mean, for example, in the conclusion at paragraph 4.1, at page 243,
well,
it begins by saying where the proposed development conflicts with the housing settlement policy of the council, it does not accord with the development plan taken as a whole. However, officers consider that there are other material considerations. But does it clearly advise the committee that there is a conflict?
Well, no, Lord, I don't think it's mealy mouthed. I think what that paragraph my Lord takes to actually grapples with the key issue in section 38.6. A conclusion has to be made, and one is clearly made as to whether there's compliance with the development plan as a whole. Now, Lord, within these kind of decisions, my Lord knows that many cases like the City of Edinburgh make clear it is almost impossible to conceive of any application of this size that wouldn't have policies conflicting with each other, and you're almost never going to get an application which ticks every box. We are here arguing, as it happens, because of the nature of the challenge, about one part of one policy in a neighbourhood plan, but the officers were perfectly entitled to report, as they did there, by looking at the development plan as a whole. And the point I would make now is they plainly, in the body of the report, referred to all the relevant parts of it. They, as it happened, gone through, as we'll see, the Thurston neighbourhood plan, as well as the other plans, in considerable detail. And they had concluded that there was no compliance with the development plan as a whole. In relation to the neighbourhood...
Is that right? I mean, just reading
Yes.
paragraph 4.1, the way I read it, was that the officer does think there's a conflict.
Yes. Yes.
But other material considerations point the other
exactly.
way.
Exactly.
Now, am I right in thinking that where you are going to make a decision which does not accord with the development, and there are special advertising procedural requirements? So I misremembered that.
There are. The Lord is quite right. Sometimes when there's a conflict with the development plan, it means it has to go into, often has to be heard by a committee, and there are other. I don't think any of those are particularly.
They're not relevant yet.
I think they're procedural matters to do with the process rather than the legal determination. The test remains the same. But the point I was making was that this is a classic case where there are many policies that are plainly complied with. Incidentally, most of the neighbourhood plan, you could argue, the officers did, apart from one part of in fact, well, they said that all of it was complied with. There will be, but nevertheless, as you were, the key settlement policies, which are out of date because they perhaps have some vintage things moved on, are obviously conflicted with. And that will be the case for any housing proposal in the countryside, even though one needs to develop in the countryside. Yeah. So they took a judgment that looking at all the policies as a whole, many complied with, some conflicted with, but the most important ones were CS1, CS2, H7, because of their strategic nature. There's conflict with them, so development plan conflict as a whole is a judgment. But the material considerations in this case, highways, other matters, was of such weight that under the section 30...
Well, I see that, but weren't the waters muddied a bit by what the members were told by the chief claimant during the meeting?
No, absolutely, because it was quite clear that he advised, and your Lord's absolutely right, that there was no conflict with that particular part. He took the view, and the Lord's seen the references, and you've seen that, and I don't go back to that at all. And we accept, which is why I think my Lord's pointed, in the report itself, it doesn't perhaps directly say there's no conflict with Neighbourhood Plan Part 1, Criteria 1.
Well, there is a conflict. It doesn't directly say there is a conflict.
No.
My question is, does the report anywhere clearly tell the committee there is a conflict with policy 1 in the neighbourhood plan?
The position is there is no conflict. That's the officer's position. Their position is there is no conflict.
All right. Well, if there's no conflict, then is there overall analysis there is no conflict with the development plan?
Yes, absolutely. I mean,
then you would be in the first part of section 38.6. You wouldn't need to go on to.
Lord, they could have done that. And incidentally, obviously, in my Lord's case that you appeared in Wild, Lord Justice Lindblom, I looked at that with interest because the judgment, and I emphasise judgment, that decision made was that, despite and the similarities were a suite of relatively old policies in the countryside were plainly out of date, conflicted with, but they focused, as I recall, on the policy in the neighbourhood plan, and found because there was compliance with it, that was the most important policy, and developed compliance with the development plan as a whole. But the judgment in here, and I emphasise that because it is a judgment, the courts have made clear, you've got to identify the relevant policies, stage 1, you then identify, for the purposes of the MPPF at least, what the most important ones are for parallel. Again, a judgment. And in this case, the officers decided that it was CS1, CS2 and H7. Yeah. And then you look at all the policies then, and some will be peripheral importance, some will be of more importance. And they decided, because there was conflict with those 3, as it were, strategic policies, because of the location of the development, notwithstanding there was no conflict with parts of the neighbourhood plan, their judgment was that it was correct to report to members fairly that there was a conflict with the development plan as a whole. They could, I suspect, if they had taken a different view, it would be a very difficult challenge to mount against them either. These are matters which are judgment. I suspect in the Wyatt case, and you could have put it this way, equally arrived at a lawful decision by finding conflict but material considerations outweighed. It depends on the. In this case, the material considerations were of such weight and importance as it was seen, and the officers felt that there was, notwithstanding no conflict with the neighbourhood plan, that it was right to report a conflict overall. Yeah.
Well, that's a very important point to always to bear in mind, isn't it?
It is.
The neighbourhood plan is not exclusively the same as the development plan.
No.
Section 38.6 refers to the development.
Indeed.
And so what you're really saying to us, I think, is that when read fairly, and bearing in mind that the officer is not writing an exam paper, paragraph 4.1 does, in substance, clearly convey to the committee there is a conflict with the development plan taken as a whole.
Indeed.
Which includes, as you've reminded us, policies CS1, CS2 and H7. But, and that's why they use the word however, officers consider that there are other material considerations, ... So you say this is a classic example which falls within the second limb of section 38, subsection 6. And it was a classic case of the exercise of planning.
Absolutely, for which the courts are wary to intervene, etc. In this case, it's absolutely right that the reference to tension in 4.1, when one has read all the papers, as it were, and seen what was reported in committee, which is relevant and obviously important. This is a case where we have the transcript. That is plainly a reference to the neighbourhood plan policy that this case has been mostly looking at in detail, because officers looked at that part, and perhaps come on to it and looked at the word focused, and took a judgment. You say that this would not be in conflict with it, notwithstanding it's outside, for all the reasons we've submitted and I'll develop in a moment. But they accepted that if, as a matter again of common sense, if a neighbourhood plan relatively newly made is asking for a focus for new development to be within the settlement boundary, even if one applies that as not saying everything has to be, it could be said there's a tension. It's a matter of common sense. It's not a tricky point. I think my Lord, Mr Mould below, in the court below, felt the phrase was confusing, I think is the way he put it.
But if you justify the decision which the planning authority made on the basis that there was a conflict with the development plan,
yes,
but that was outweighed by other material considerations, does it matter whether the officers misconstrued policy 1 in the neighbourhood plan?
Well, I think I would say no in the facts of this case. I think, to be fair, the way it's put, I think in the case was if the construction is of a very important policy and would have had a material difference in the outcome, if it could be said in this case, and I say it can't, but for the sake of argument, they had found actually we're going to conflict with part 1 of policy 1. We still comply with policy 7, policy 9, and incidentally probably other parts of that same policy. It would be said, I think, well, that's an important consideration members would want to have in mind. They were clearly concerned. There was a lot of discussion in the transcript about whether the neighbourhood plan was complied with. So I think it would be said on my own friend that would be something that would have been relevant in the balance. Now, in my submission, in a sense, even if you're against me in due course on the construction point, or as I put it, the application point, I think there's a serious point which Mr Mould looked at below as to whether it would have made any difference, frankly, given the nature of the material considerations, and given that in this case it was already being reported, there was a conflict with the development plan. So I think that my submission would actually go to relief as to whether it would have made any difference.
Well, I know that may be the right way of looking at it. Speaking for myself, at this stage only, I'm not sure. You see, I think that one of the lessons that Wyatt teaches, and this is by no means the first case which has made this point, but it's a recent planning case in this court, and so it may be helpful to consider it. But one of the lessons it teaches is that it is frequently the case that a development plan contains policies pulling in different directions.
Yeah.
And that merely to point out that there is a conflict with an individual policy is not to answer the statutory question posed by section 38.6, which is there conflict with the development plan as a whole? Now here, I speaking for myself, find it very instructive that the way in which paragraph 4.1 begins is that it tells the committee, the officer's view is, it does not accord with the development plan taken as a whole. However, material consideration.
Yes.
So, as my Lord puts to you, this seems to be, on the face of it, a classic application of section 38.6. Now, if that's right, and it may not be, but if that's right, one is left wondering Why does it matter?
Well,
If along the way, this individual policy or that individual policy, they may have got slightly wrong.
Lord, yes, you put it far more eloquent. I'm tempted to sit down, but I won't. That is indeed the way I would put it. And in the Wyatt case, well, it happened to be argued by Mr Mould and on behalf of the council. The issue there, maybe some similarity, was already the word adjacent, wasn't it? Now, there is a great danger, and I don't for a moment suggest one can transfer any of the facts over as many cases, because each case is different. But it's interesting, in that case, the court, which I think is part of the approach the court's been developed in the difference between construction and application, were of the view, well, adjacent isn't defined, and it's a matter of judgment. And in the sense, although there was some partial conflict with a part of, I think it's DSP 40 in that case, it didn't go to whether there was compliance with the other side of the coin in that case, the way it was structured. So what I would say, there isn't an analogy in this case. I respectfully agree. One can argue, as one has done because of the nature of the way the claim was put when it came to the High Court of Judicial Review, that it's very important whether there was a construction and they construed focus correctly. We've always taken the position, didn't succeed below, that in fact on a straightforward construction, as one applies in planning terms, not like a statute, not like a contract, there's no conflict. But in any event, in the same breath, what we're really saying is this is really a matter of application. Focus is not a defined word any more than adjacent was in Wyatt. It is a word which quintessentially requires a judgment to be made by officers in light of circumstances. And incidentally, it is entirely possible, for the sake of argument, that a further development in a few years' time outside of the boundary might be said to be in conflict if by that stage there were many more developments outside. What one's applying the word focus as an officer. Have we reached a stage where there would not be a focus anymore? So these are all matters of judgment. In this case, there was a clear view. I don't think it would make any difference anyway had they taken a different view on the facts of this case. But that is, in a sense, I think, the relief point, which may actually be the most important point. But it was not a point that found favour below.
The settlement boundary, is this right, you said was extended to include the Thurston 5.
Yeah.
And the Thurston 5 produce 650 dwellings.
Yes.
And this proposal produces 200.
Up to 210, maybe less, but couldn't go higher than 200.
So simply comparing the 650 to the 200, might one say that development is indeed focused within the settlement boundaries?
Yes, well, yes, I think is the answer. It's a matter of judgment. I think it certainly wouldn't my submission be in the realms of being an irrational judgment to make or an irrational application. Plainly, the officers set out all those facts and figures and plans before the committee in recommending permission in the way they did. But Lord, yes, I don't think it would be to say there's not any more a focus just because you're allowing a development. You've got 5 inside. This is the first one, as it were, that's coming outside. Lord, I'm going to, so far as the report is concerned, I'm going to move on to, I think, to my more focused submissions on the plan. But as we've really been looking at, the report did in terms look at the Thurston neighbourhood plan in some detail, as well as the other policies, and set out a comprehensive assessment of all the policies. It looked at, and Lord, if I just take you to 211, just to focus on the 211 of the bundle within the report. And you'll see within there, it actually, the previous page at the bottom is the heading of the neighbourhood plan. This is the part of the report actually beginning on 210, forgive me, that the report goes into quite a lot of detail about, starting with S1, which is the spatial policy of the neighbourhood plan, and then over the following few pages, as I know this court has read, so I go quickly, then details and in fact breaks down various parts of the policies within the neighbourhood plan. So it looked at that in detail and formed the conclusions it did. And the subsequent oral advice, as you've seen in the transcript, which really echoes the position in the report, was that there was no conflict with the neighbourhood plan. And that was the position that was reported to members, as we've seen. And then finally, just before I turn to some detailed submissions on the grounds, that there is the balance that my Lord's taken me to a moment ago at section 4 on page 243, which, as it were, draws the matters all together and is set out in those important paragraphs. 4.1 we looked at a moment ago, and then reference to the joint local plan in 4.2, and the range, as it were, as one goes through to 4.3 of benefits and material considerations, some of which I've touched on in submissions, but not all. And the reference again and the emphasis that even the county council as a local highway authority has indicated it's not in a position to deliver the package of improvements which this proposal could in relation to highways. So that's the way the report put matters. In my submission, a comprehensive...
Just before we leave the report, at the end of paragraph 4.1,
yes,
and we've seen this point made in several places, it states that the proposed development is clearly a sustainable development proposal in line with the NPPF.
yes.
For the purposes of this appeal, is there any dispute about that?
Well, yes, I think there would be. There would be a great dispute. Sustainability is very broadly defined, as my Lord knows, in the NPPF. And in essence, it's a rather circuitous point, actually. If one gets through the hurdles in paragraph 11, the tilted balance, which another balance as a material consideration, you pass that, so that then you are by definition, as it were, sustainable within the meaning of the NPPF. If you don't, you're not. So I think my learned friend would say, had this been looked at properly and the conflict was appreciated, you wouldn't have. Well, he would also say the tilted balance wouldn't apply. But on any level, I think his case would be it wouldn't be sustainable within the NPPF. That's not.
Is that an issue in this appeal?
I don't think it's a particular issue in this appeal because in a sense, if you find the section 38(6) process lawful, it is almost by definition sustainable.
Yeah. Right.
So I wouldn't accept it sustainable as a real issue. Lord, I was going to briefly deal with legal context. I've made some submissions on Wyatt in a sense already, and I don't wish to go over that again unless there's anything my Lord would particularly wish to flag up to me. But the broad point I take from that really are two things. One is I don't seek to rely on any of the facts as similarities, but there is either so, in my submission, there is an indication from the court that one should apply these kinds of policies with a spirit of realism and common sense, as Lord Justice Lindblom puts it, and that's something that's been echoed in many of his judgments in the last few years, and that is a point that I think is of particular relevance in this case. Lord, in the authorities bundle, you have a number of authorities which say similar matters. I touch on them very briefly because I think I need not trouble you at all. In relation to the approach to officer reports that my Lord's already mentioned, the sense of benevolence and fair reading, it's emphasised in this court's judgment in Mansell, which I don't think I need to take you to the principle set out.
Are we going to get much from these authorities?
No.
I think
I don't think
we're
we will.
treading very well-trodden ground.
They are. Lord, I would, indeed. And I think you will, I hope, have had the opportunity to look at the two cases which, the Gladman developments against Canterbury and the Chichester cases, which both cases Lord Justice Lindblom emphasised in the context of construing or applying development plan policy, how the court should not approach these matters with the same linguistic rigour as one does in a contractual statutory case. You've got to look at the context, and by that I think the court means the full context, not only the supporting text, but also the material considerations and the on the ground evidence which may or may not exist in any given time. That is the, I'll put it this way, that is the essence of good planning. It is inevitably blurry, it is inevitably not all neatly ticked in boxes, and it does always pull in different directions. So Lord, I don't think I need to dwell on those authorities, and I'm going to move on then to develop briefly in light of what's already gone forward the grounds. Ground one relates really just to this issue of construction of policy one of the neighbourhood plan. Lord will find policy one at page 105 in tab 7 of the core bundle, which is the neighbourhood plan, obviously, and it is set out there with A, B, C, D, and E. And as we've seen, my lords have picked up, in officers in essence advised members that there was a tension with parts of the policy, in particular the part of the reference to focus, but viewed in context, there was no conflict, particularly in their view when the context of the emerging local plan was understood. And Lord, as I've mentioned already, even if one gets into the realm of looking at construction, in my submission it couldn't be sensibly argued that the phrase "shall be focused" precludes any new development outside of the settlement boundary, even if one were suggested it was a construction case. The officers considered and reported not only the plain language of the policy, but also, as they were required to do, the full context of the background in their report, as we've seen. In my submission, they did so, and members followed that quite properly in applying the policy to achieve what they considered to be a practical decision, very much in the public interest, particularly given the significant material benefits that would be brought to Thurston. Now, Lord, can I just look in a little bit more detail at some of the textual references in the neighbourhood plan, which were looked at in some detail in the report below. And Lord, if I could take you to page 77, which is the beginning, section 1 of the neighbourhood plan. And I will quickly mention some of these, because it is important to note, I think, that when one reads the purpose of the plan, at 1.1, it is stated the document forms the plan for Thurston to the period 2018 to 2036, contains a vision, as it puts it, for Thurston, and sets out clear planning policies to realise that vision. And the purpose, it is said in 1.2, is to guide development within the parish. The parish is, as it happens, a more extensive area, slightly than the settlement boundary. This proposal is within the parish, again as it happens, but outside the settlement boundary. The plan recognises within this section, particularly looking at 1.6, the plan recognises, in my submission when you read 1.6, that in a sense one's looking at, reading and understanding this document, this part of the development plan, in the context of what's emerging, what's coming forward. There's reference there in 1.6 to the consultation, the regulation 18 consultation, part of which I showed you earlier on, with this site as an emerging allocation within that. So that is, then if one could go, if I could take you to section 2, beginning at page 81. And this is the part of the neighbourhood plan headed Vision and Objectives. And it is noted, perhaps of some relevance at 2.1, that the key challenge for Thurston is to provide appropriate sustainable development and an infrastructure that supports it whilst retaining the quality of the village. And I flagged that up particularly because when one looks at 2.2, which begins more specifically, when one looks at the various bullet points that follow, it is plain that several of them are explicitly relating to highways issues, particularly bullet point 4 on the bottom of the left-hand side column, the roads leading to surrounding villages, and then the first bullet point on the top right-hand side, the narrow road underneath the rail bridge, which is actually one of the matters specifically dealt with, as you will have seen in the report, by this proposal. So the underlying context, as is made clear, not only in the policy later on, but in the vision and objectives with the neighbourhood plan, is very much in mind highway matters, as well as the first bullet of 2.2, the particular kinds of housing, notably for younger people who often move out of the village, a familiar problem with affordability. And of course, well, we'll see one of the other benefits of this proposal, it would provide potentially up to over 70 affordable houses as part of the percentage, 35% it was required to deliver. So there was a recognition in the vision and objectives that there were many highways issues that needed resolving in Thurston. Then, Lord, section 4, the next part I take you to, which begins on page 103, And there we have the heading Spatial Strategy, and the S1 policy, not to be confused with the Policy 1 that follows later, but the objective at that level is to develop and sustain a key service centre status of Thurston by ensuring any future development is sustainable and supports a range of employment services and housing. It notes in 4.1 below that Thurston is, has a status, you'll see this in the penultimate 2 lines of 4.1, as a core village. That's within the emerging local plans. There's reference again to looking forward to what's coming, because in the emerging local plan it was described as a core village, and there's a recognition in that last line of 4.1 that Thurston will need to play, quote, a key role in addressing that need. So it's explicitly, by way of context, a plan which is looking ahead to what's coming, recognising it will need to play a key role in addressing the identified housing need. And that housing need, as I said at the outset, is not being done by this plan, it's being done by another plan that's coming forward, the joint local plan. And moreover, that need is recognised for being, quote, for significant levels of housing growth. So that is the explicit reference, as it were, that the need is going to be determined by another part of the development plan that's on its way at that stage. At 4.2, again, the neighbourhood plan in terms is acknowledging it will be for the joint local plan to address the need for Thurston to contribute to housing, to meet the required housing growth, as you will see in 4.2. And you'll see, as one goes to the bottom of 4.2, you will see, and this is a point that I think Mr Mould below focused on in his judgment, because he prenated this part of the text. It's right that I flag it up to you. He said, I'm looking at the bottom 5 lines from the bottom of 4.2, it said, it's not expected that significant additional growth will need to be planned for in Thurston to support the emerging joint local plan. One might say that's slightly contradictory from what went before. In light of this, it says, the spatial strategy seeks to be more restrictive as to the types of development which can be brought forward outside the settlement boundary, in line with Mid Suffolk core strategy policies CS1, CS2, in order to reflect a positive approach. However, it is considered appropriate to provide some flexibility to address particularly significant needs identified. And then it goes on to talk about the particular categories, including sheltered housing and bungalows. And so I think His Lordship, Mr Mould below, took the view in his construction was that, okay, you've got focus, but what this strategy is saying is focus within. There are categories you can have outside of the settlement boundary, and look at 4.2, and those are the kind of categories you can have sheltered housing, rather than the general free-for-all. Now, our submission, plainly the structure is to allow, and in fact the specific support for those kind of categories, but when you understand the full context of what was needed that I've been through already, looking forward, again, one goes back to what does focus mean, and it does not preclude other kinds of housing coming forward as a matter of judgment. That was one of the differences, I think, in interpretation between the way we were putting it and the learned judge below in his construction. So I flagged that up. I also mentioned, if I may, 4.5, it's important to note this point. It is said, therefore, the general approach in the Thurston neighbourhood plans that growth will be focused on the sites with planning permission, those are the Thurston 5, which are located within the settlement boundary and on small-scale infill sites within the settlement boundary. And then it goes over to 4.6. The neighbourhood plan identifies the sites in the planning pipeline which are expected to deliver housing. Those are the Thurston 5. Then it goes on and says, more generally, these sites and other developments are expected to provide high-quality schemes which generally enhance the public realm and improve accessibility for pedestrians and cyclists. And that, again, reference to other developments is my submission, not precluding other developments coming forward. Were there any doubt about that? If one goes on, if I may, just to take you a little bit ahead to 5.7, which is within the section dealing with housing and design. and there's quite a lot of text on page 106 about the background. But on page 107, there's a relevant paragraph 5.7, and it says that the neighbourhood plan's policies identify the issues that future development should address and provide criteria to ensure these are achieved. These policies shall also apply where relevant to the site's recently granted outline planning permission without reserved matters approval. Over the lifetime of the neighbourhood plan, so in other words 2036, and providing infrastructure limitations can be overcome, housing growth could potentially be accommodated in a sensitive way within the parish. That's, as it were, not limited to the settlement boundary. Such development would be tailored to address the housing needs of each sector of the population and would help meet the housing objectives identified again in the joint local plan. That's the emerging plan.
And the infrastructure limitations are those identified at 4.2, is that right? Highway capacity and the need for new educational facilities in the shape of a new primary school.
Yes. So, Lord, it is in that context that one looks at policy 1 on page 105, which I've been avoiding directly until now. Policy 1 consists of 5 limbs, and as you know full well by now, limb A indicates that new development in Thurston, quote, shall be focused within the settlement boundary. So in our simple submission, I hope, is that just on a matter of common sense, looking at the wording, does not preclude against any development outside of the settlement boundary. As it happens, that is clear from the context. The development site before you in this case is outside of the settlement boundary, and so to that extent it might be said, and in fact it was said and reported to members, that there's a tension. I mean, it seems to me a common sense way of putting matters. There's a tension with policy 1A, and that was recognised both in the report in 4.1 and in some of the oral advice given to members in the committee. But whilst the NDP, the neighbourhood plan as we've seen, did not consider it necessary itself to identify further sites to 2036, it follows, given all the references, there's no preclusion. Indeed, one could say there is a natural inference, just looking at that, read in context, that there may well be a need for further sites in 2036. The neighbourhood plan, I think, anticipates that. And also, that the local plan policies as emerging would assist in determining whether applications should be allowed outside of the settlement boundary. And in that context, which is plainly in the mind of this plan, new development being focused within the settlement boundary does not preclude development outside of it. In my submission, whether or not there's a conflict with that policy will be a matter of judgment depending on the context at the time and the context we've looked at now. And in this case, applying proper interpretative principles, there is no conflict with the NDP in the way as the officers correctly advised. Now, Lord, I had references to the transcript, but I know you've read the transcript and you've seen the way it was put, so I don't go to that. I think you and I'm just going to draw those conclusions to a close by summarising, saying it is, as I said at the outset in my respectful submission, a classic example of a planning balance being carried out in the context of some competing policies, judgments being required at a number of stages, made in a wholly lawful way, and that approach, that judgment and approach to what focused means, if you like, was in any event entirely bolstered when one considers, as the report did, the extent to which this proposal made significant contributions to meeting not only housing need, but also the other infrastructure requirements of the plan. Now, the judge below, His Lordship's Mould, concluded, as you know, that there was a conflict with Policy 1. He felt because that hadn't been reported to members, either in the report or orally, that led to them being materially misled, which is obviously the test that one has to meet. Our submission is that is incorrect in law. The judge, with great respect, was incorrect in that regard. And for the reasons I've said, the recommended application of policy by officers to members was entirely lawful. Lord, I do flag up that even if one is in, as I can put it, not in the cul-de-sac, if I can put it that way, of a construction argument, even if you were against me on that point in my submission for the reasons I've said, it wouldn't have probably made any difference in any event. And so, in a sense, looking at the section 31 discretion, it is highly likely that the outcome would not have been substantially different in any event. Can I very briefly do...
Forgive me, Mr. The reference to section 31 of the Senior Courts Act is not one I picked up previously.
No.
It's not an issue in this appeal, is it?
No, it's not, Lord. I mean, I'm not, in a sense, if I'm successful in my arguments, I didn't need to go there. It was mooted by His Lordship, not in direct terms, but in a discretion debate at the end of his judgment below. And I anticipate some of the early debate would have made any difference. That's why I mentioned it.
I see.
So I think you're absolutely right. It isn't specifically argued or mentioned. But in the sense, the court, obviously, I'm aware, has an inherent jurisdiction if one got to that stage where you might want to consider that. So that's the only reason I raised that. Lord, the other two grounds are, if I can put it this way, entirely parasitic on the first. And so I take them very quickly. The second ground of challenge was, in essence, that the initial ground of challenge in the High Court below was that members had been wrongly advised in relation to the tilted balance. That's the balance in paragraph 11D of the MPPF, which you rather belatedly been provided with a copy with this morning. And Lord, as you know, the judge below had concluded that the application of what's known as the tilted balance, which is in effect the balance at 11D, D2 of the MPPF, the judge below concluded that tilted balance was legally flawed solely, as the judge found, because of the misinterpretation of policy 1. And the judge below, in his judgment, explicitly concluded the issue was not the breadth of planning judgment offered to the decision maker, which was run as an argument below, but the judge didn't accept that, but rather the judge felt that the exercise of planning judgment was likely to be vitiated by the, as he saw it, the legal error in respect of ground 1. Now, so to put it simply, for the reasons I've already submitted in relation to the application of policy, we submit respectfully that his conclusion in relation to 11D was wrong in law, and it follows that if you're with me, as it were, on the first ground, that must fall away in my submission. And finally, ground 3, as I put it in our ground of appeal, that there was also a point that it was alleged that members have been wrongly advised in the application of paragraph 14 of the MPPF. And again, as you will have seen, Lordship below agreed with our submissions and my learned friend to my right submissions that, contrary to the claimant's case at that stage, paragraph 14 is only engaged where all 4 of the constituent parts, A, B, C and D, are satisfied. Roger's with us on that. But again, he concluded that the report's analysis, the committee report's analysis of 14B, was vitiated by the misconstruction of policy 1, is the way the judge put it in paragraph 91. And again, for the reasons I've submitted already in respect to policy interpretation and application, we respectfully say his conclusion on that front is also wrong. Lord, unless there's anything else, those are the submissions I make.
Thank you very much, Mr. Cosgrove. Yes, Mr. Tucker.
My lords, my lady, I will try not to repeat the submissions of my learned friend Mr. Cosgrove. Where I do, I apologise in advance, but I'll seek to skip over points I would otherwise have made. I hope to be comparatively short and hope to add value using the colloquialism rather than to make Mr. Tucker. Yes, I always have to be marked to the end, my lord. My lord, fundamentally, this is a simple case, and it's directing my attention, or the court's attention, to paragraph 74 of the judgment of the judge below, where there were 2 points that were made. Firstly, the judge found that there was an error in the construction of policy 1, and that there should have been a conclusion that the policy was breached rather than not breached, and tension with it. And the second element of that was, therefore, there was tension with the locational strategy of the neighbourhood plan, and that members should have been more closely advised in relation to that locational strategy. Venn diagram in terms of elements from the neighbourhood plan, but they all come to the same point, a misconstruction in terms of the overall approach to policy 1. Well, my lords, my lady, if I may, there are some things which are blindingly obvious from the documentation, standing back from it and looking at matters fairly, and looking at the conclusions that are paragraph 4.1 and 4.2 of the officer's report, together with page 57 of Tim Mould QC's judgment, paragraph 42-43, where he quotes from the transcripts, and it's those relevant parts of the transcript which quotes from the Chief Planning Officer. I say, in fact, the Chief Planning Officer got it right, and I'll explain why he got it right, because it's big picture submissions here. Firstly, it's quite clear from paragraph 4.1, as my lords have already discussed with my friend Mr Cosgrove, it's quite clear from 4.1 that the conclusion was reached and members were being urged to conclude that there was conflict with section 38.6 and that we were in the territory of other material considerations. That's crystal clear. Secondly, members were very clearly advised that this was a site which was not allocated within either the local plan, core strategy, or the neighbourhood plan. There can be no doubt about that. Third, members were clearly advised that this was a site that was located outside of the defined settlement boundary, both that which is from the local plan and the extended settlement boundary to include the Thurston 5 in the neighbourhood plan. My lords, my lady, I don't know if the court wants the references we go through for these comparatively self-evident points, but for example, that proposition arises from pages 173 and 211 of the core bundle, but I won't take the court to those. I don't think it's necessary. The fourth point is development of the site would, in the view of officers, clearly breach countryside policies in the local plan, particularly CS2 and H7. And one gets that from pages 158, 160, 161 and 224 of the bundle. And indeed it's breach of those policies which lead to the section 38.6 conclusion, I note in passing. Next point, fifthly, that the local plan was considered to be out of date. Gets that a number of places, for example, core bundle 159. And next point, which comes through with clarity from both the Chief Planning Officer's observations, but also repeatedly through the officer's report, is that the neighbourhood plan does not support development beyond the extended boundaries of Thurston. That's absolutely clear. So members were aware, bringing all those points together, that there was a breach of important policies which led to the section 38.6 balance being tipped against my client's proposals, and that there was indeed no support for the proposals beyond the settlement boundary from the neighbourhood plan policy or indeed from the core strategy or the local plan. What is said to be the error which vitiates the conclusions of the officer is that by telling members that there was a tension between policy 1 and the overall approach of the neighbourhood plan, rather than there being a breach of policy 1 and the locational strategy of the local plan, that the officer's report fell into legal error. With respect to the confection of the submissions my learned friend Mr Lewis is about to make, that falls into the realm of legal nitpicking in my respectful submission. We are dealing with the minutiae of policy interpretation, but in any event, I say that the conclusions of the officer is absolutely right, and perhaps I can seek to demonstrate that by reference to the Chichester case. Firstly, if I may, just turning to policy 1 itself, which is page 105 of the bundle. I apologise, my lords. Mr Cosgrove has already made submissions about criterion A and the word focus, and that the word focus is not a preclusive term. So I won't repeat those submissions. Criterion B, development proposals will be supported within the settlement, or within the settlement will be supported, subject to compliance with other policy and neighbourhood plan. Also, part of the policy relied upon by the judge below. My lords, my lady, if one bears those words in mind, development proposals within the settlement boundary will be supported, and then one turns to the Chichester case, which is at tab 6 of the authorities bundle, page 133.
I don't have tabs, but anyway.
I do apologise,
133.
Mon. It's page 133 it
Yeah.
starts. And there were, in 2019, this court was troubled by 2 cases involving neighbourhood plans, this being the most recent one, the Kent case being the earlier one, both judgments of Lord Justice Lindblom giving the lead judgments of the court. This one, my lords, my lady, deal with, at page 7, a policy of the neighbourhood plan in that case, which has a certain resonance to criterion B.
Do you mean, sorry, do you mean paragraphs?
I'm so sorry, Mon. I've managed to
Page
print it out without pages. It's paragraph 18.
Paragraph
Page 140.
I will find.
18. Yes, got it.
I confess that I printed out separately and the page numbering hasn't come out on my printing, so I apologise.
If we could have paragraph numbers, we can manage.
So it's paragraph 18, dealing with policy 1 of that particular neighbourhood plan, which said the neighbourhood plan will support development proposals located inside the settlement boundaries and gives the settlements as shown on the policies map, provided they accord with other provisions of the neighbourhood plan and development plan. Almost identical wording to the ones in this instance. If one then turns to the discussion, which in this instance starts at paragraph 30, and is certainly worth reading.
Sorry, I've lost track. Where are we?
This is the discussion, my lady. It's paragraph 30.
In the case.
In the case.
Yep.
So this is then addressing Mr Guion-Lewis, QC's argument, unsuccessfully in this case, that policy was a policy which was preclusive in terms of development outside of the settlement boundary, that being the alleged legal error, which then led to a misinterpretation of the relevant part of MPPF. So it was almost on all fours with this instance. So Lord Justice Lindblom rejects Mr Lewis's argument of paragraph 30.
Sorry, what's the argument?
Sorry, my lord. The argument was, if one looks at paragraph 28,
In conflict.
was alleging that there was plainly conflict with the aims and policies of the neighbourhood
Right.
plan.
In conflict because it was outside the settlement boundary.
Yes,
And not an allocated site.
my lord, yes. Hence the resonance with this case.
Yeah.
And if one looks at paragraph 29, my lord, one finds what the inspector concluded, essentially that there wasn't such a conflict. And that was the alleged legal challenge being brought by the District Council, in that case represented by Mr Lewis. So, just to pick up, but I don't propose to read out all of the paragraphs. This case follows on 2 previous cases, which were the references to Crane and Gladman in Canterbury City Council, which one sees at paragraph 31,
Yeah.
in which the courts concluded that there was an obverse of a policy which was supportive of development within the built-up area of a settlement, that outside of the built-up area, that the policy should be construed to be preclusive of development in that location. So the argument being raised in this case was, well, hold on a second, those authorities should lead to the conclusion that if there is development outside of a settlement boundary, even though the policy says nothing about preclusion outside the settlement boundary, one infers that preclusion. And it being suggested that there is clear authority in that case. And what Lord Justice Lindblom does in these paragraphs, I'll take the court to in just a moment, is says, well, you've got to look at each plan individually. One has to look to see whether or not the plans as a whole should be read in that way, so that there is that obverse of a positive supportive policy, which then results in a preclusive policy. And the distinction that's drawn by Lord Justice Lindblom, if I can just take the court to paragraph 45, because Lord Justice Lindblom rejected Mr Lewis's argument, but the distinction that he drew between the Crane and the Gladman cases was that in those cases there wasn't a settlement boundary, and that therefore outside of the existing built-up area in those cases was concluded in the particular facts and circumstances of those particular neighbourhood plans and local plans to warrant the conclusion that there was that obverse of the supportive policy. Now, it's fair to say that's not just the reasoning that was found, but that's the big ticket item that distinguishes the policy approach, because the remainder of the discussion, which goes from paragraph 40 through to paragraph 44 of Lord Justice Lindblom's judgment, asks the question whether or not we are dealing with a neighbourhood plan and a local plan which has a complete set of policies, so that one doesn't have to look at the neighbourhood plan to identify the preclusive policies. And in that case, my lords, my lady, if one looks at paragraph 41 of the judgment, he observes, there is no other policy of the neighbourhood plan governing the suitable amount and location of housing development in the parish of Southbourne, none for unallocated or windfall sites, and none to refine the criterion-based approach of development outside of settlement boundaries in policy 41 of the local plan. No policy in the neighbourhood plan replicates policy 45 or provides a different approach for proposals for development outside the settlement boundaries. There was no need to include such a policy in the neighbourhood plan. It would have been inappropriate to do so. As Mr Garvey submitted, if a stricter or more liberal policy for development needs for developments outside the settlement boundaries had been inserted into that plan, it would have upset the carefully formulated policies for such proposals in place in the recently adopted local plan. It would have clashed with policies 2 and 45. Now, in this case, one has the policies from the local plan, albeit out of date, but about to be replaced by the emerging local plan, which does tell you what happens for development outside the settlement boundary. It tells one that one shouldn't do it, say for a limited number of developments which aren't relevant to this particular case. So one has the preclusive policies CS2 and H7 in the local plan, and one has the supportive policies in the neighbourhood plan. One has, frankly, the same situation, albeit one doesn't have a criterion-based policy in this instance, but where one looks at the local plan to see if there is a preclusive policy, and there is. So one doesn't have to read into the neighbourhood plan the preclusive element. Now, in fairness, the local plan and neighbourhood plan at the time of the Chichester case were going through the process at the same time. But in this instance, we have an emerging plan that's coming forward, and sometimes emerging local plans don't come forward at exactly the same time as neighbourhood plans, and neighbourhood plans have to catch up. Well, in this case, for the reasons my learned friend Mr Cosgrove has indicated, this is a neighbourhood plan that's been prepared explicitly in the knowledge that it is going to be catching up with the local plan in due course, because the local plan hasn't yet been made. So I say it's nothing to the point that the local plan wasn't up to date in this case, and it was in relation to the Chichester case, because there was a suite of policies adding the local plan and the neighbourhood plan together. In short, this is a case where one doesn't need to read in preclusive elements of policy 1 in the way being argued for by the parish council, because there is already those preclusive policies, and it's those preclusive policies which led to the conclusion that this is a proposal not in accordance with the development plan. It is right to say there are distinguishing features between the Chichester case and this case, and I certainly urge the court to read that part of the judgment of Lord Justice Lindblom in full, and I hope my lords will, and my lady will forgive me not reading out 3 pages in full, but they are, in my respectful submission, extremely informative in relation to the outcome of this particular case. And I say that that's the failure, with all of the due respect of the judgment of the court below, not grappling with the nature of this particular case. Had one done so, then it would make sense of what the officer reported, both in the transcript and in the officer's report itself, which is to say, there was tension with the neighbourhood plan. As Mr Cosgrove rightly says, it's an ordinary word. There's tension with the neighbourhood plan, but that doesn't mean there's a breach of the policy with the neighbourhood plan. Indeed, sufficient was the tension with the neighbourhood plan that the officer goes out of his way, I think, to observe, well, this may be a big disappointment to the villagers of Thurston. It's a point that's made in a number of different places in the officer's report. But that doesn't demur from the fact that in this instance, the parish council are inviting reading into a policy preclusive elements that just aren't necessary, because those preclusive elements are to be found elsewhere within the development plan read as a whole. Which then does lead me to support the so what point from my learned friend, which my lord asked towards the start of my learned friend Mr Cosgrove's submissions, which is, well, what was it that members weren't being told? Members weren't being told, supposedly, that it's contrary to policy to be outside of the settlement boundary, because it said you can read that into policy 1 of the neighbourhood plan. With respect, members were being told emphatically that it was contrary to policy to be outside of the settlement boundary, and that's why there was a breach of section 38.6. But there were other material considerations which were brought into play. For example, the fact that the neighbourhood plan expressly demurred from bringing forward its housing need. And just to make good that last point, my lord, my lady have sight of the extract from MPPF, which I seem to have laid aside. Thank you very much, Ms. Perrick. Paragraph 14 of MPPF is debated in some considerable depth within the officer's report. The reason for that being that where the tilted balance is engaged, that the weight to be afforded to the tilted balance is then diminished if one complies with paragraph 14, and in relation to paragraph 14 that was found by the officers not to be engaged because not all of the elements were met. B is the important element, namely this is not a neighbourhood plan which contains policies and allocations to meet its identified housing requirement. It doesn't need to, there's no statutory obligation or policy obligation, but they could have done so. And it's perhaps that nuance that causes the reason why the officer puts contrite terms within the officer's report saying this may be contrary to the expectations of the parish, because they may have expected we've got an up-to-date neighbourhood plan which has got an up-to-date policy and which identifies permissions. So why on earth are we allowing a further consent being granted outside the settlement boundaries? Answer, because the neighbourhood plan didn't deal with their up-to-date needs up to 2036. It deferred those to the local plan. And whilst that may be the sort of geeky point that would only be apparent to planners, with respect, that disappointment to the local residents, whilst understandable, does not detract from the legality of what officers were saying. My lords, my lady, can I just pick up, I think, one point that was raised during the course of submissions, which, the jumping the gun point, if I may. This was
I think that's what the judge thought.
I think so, my lord, and the judge was perhaps over-enthusiastic in relation to matters, because there's a statutory obligation upon an authority to determine a planning application at a point in time, not to wait until the local plan is adopted, because we don't live in a perfect world, unfortunately, and the needs which have been identified were immediate needs, and my clients were keen to get on with the development at the time, and this was not a case where there was refusal on the grounds of prematurity. So, my lord, yes, perhaps that was part of the thought process of my learned friend, of the judge below. However, it's not a matter which saves the judgment from what I say is error. My lords, my lady, unless I can assist you further, those are my submissions.
Thank you very much. Yes, Mr. Lewis.
May it please you, my lord and lady. My lord, as is agreed between all parties, the central issue in the case is the proper construction of Policy 1. My learned friend, Mr Cosgrove, for the council, has in effect foregone the need to address ground 2, but I shall pick up one or two points in relation to that because they're relevant. They become relevant again to ground 1 for reasons which I shall seek to elaborate. Second opening point I would make, my lord, is, and this is an important one, when one looks at the learned deputy judge's judgment below, that construction of a development plan policy is, of course, a matter for the court to determine. And that emerges from the Canterbury/Gladman case of paragraph 22. I don't take up time going to the authorities.
Back to Tesco and all those cases.
Indeed, my lord, it goes back to Tesco as well, my lord. But that said, my lord, the deputy judge who determined this case at first instance is a particularly expert tribunal in relation to planning law and the nuances to be taken into account. Argument was heard over 2 days in relation to that, and I'll come back to section 38(6) in a moment or two, but the case of Wyatt, which my Lord Justice Singh decided in April, in fact, it involved as counsel the same planning silk, Mr Mould, who determined the Thurston Parish Council challenge at first instance. So, long and short, my lord, Mr Mould is absolutely steeped in the planning principles which apply both in relation to construction of development plan policy and equally in relation to the duty of the decision maker and in construing that subsequently the approach of the courts to how the section 38(6) exercise has been discharged. And my lord, this appeal involves my learned friends demonstrating that the learned deputy judge's construction of Policy 1 was wrong. And so one looks for grounds of law on the basis of which they say he erred in his interpretation. And I'll forecast where I'm going with this by saying, in effect, that they're simply inviting this court to find the learned deputy judge's approach to have been wrong. But I'll look at what's said by way of allegations of error in law. My learned friend, Mr Cosgrove, said at one point that the approach of the learned deputy judge had been perhaps too legalistic. He used that word, but in my respectful submission, I reject that entirely. As we'll see in a moment or two when I go back to it, the learned deputy judge looked at the wording of the policy and he construed it in his appropriate context, which is the exercise by law he was required to undertake. Secondly, Mr Cosgrove said that we're going to look at the word focused in a second or two, but he said it can't sensibly be said that that precludes development outside the settlement boundary. Leaving no room for doubt about it, the Parish Council does say that Policy 1 does preclude development outside the settlement boundary, save in one exceptional case, which is dealt with in the policy itself. Come back to that. And so Mr Cosgrove says can't sensibly be argued, in effect, saying that the learned deputy judge reached a conclusion which he couldn't reasonably have reached. That's how it's put, if it's put as a test of law at all. Similarly, my learned friend, Mr Tucker, what he said, but it's blunt. Forgive me, my lord?
Why is the question whether the judge reached a conclusion he could reasonably have reached? If it's a question of construction, it's a question of construction.
Well, very well, my lord, but that seems to be the way it's put by my learned friend for the council, that if he's saying it can't sensibly be argued the policy precludes development, in my respectful submission...
Well, either it does or it doesn't, as a matter of construction. That's the point that emerges from Tesco. I mean, you may take a perfectly reasonable view of what a policy means, but if you're wrong, then you've misunderstood it.
And yes, and there's a greater breadth for difference in the application of the policy after the point of construction. But okay, well, I won't waste time on that, my lord, but simply pick up that what my learned friend Mr Tucker said about the point of construction was that it was blindingly obvious. But in my respectful submission, it is not. And the short point for the parish council is that the learned deputy judge was correct in the decision he reached for the reasons which he gave. And for that purpose, my lord, I will go back to his judgment, if I may, please. That's tab 5 in the bundle. And it's page 64 and following. Paragraph 64, forgive me, it's page 62 of the bundle, paragraph 64 of the deputy judge's judgment. And at the top of the page, he sets up the debate by saying, it's the first lines on the page, crux of the defendant's interpretation of the policy, etc., is that although it focuses new development within the development boundary, it doesn't set up a barrier, the word which we've heard before. But the judge goes on to deal with that in paragraph 64, and while he says there's no explicit support for the defendant's interpretation, he then goes on to look at what is clearly stated in paragraphs A and B of policy 1. And I don't know if it assists the court, but I've got my copy of the judgment loose, and I was going to take the court, if I may, to the development plan policy itself, the neighbourhood plan policy, at page 105 of the bundle. And so reading it through, and in relation to all of these statements by the learned deputy judge, the parish council agrees, my lord, for the avoidance of doubt. So sentence number 2 in paragraph 64, the judge says this: the purpose of the defined settlement boundary is clearly stated in paragraphs A and B of policy 1. So looking at what that says at page 105 in the bundle, we've got A, which is the one where focused comes from. And in my respectful submission, I do submit that that precludes development outside the development boundary. You could substitute, I know it says focused, and I'll come back to that in 2 seconds, but in my submission that means located within. It doesn't mean, as it were, directed towards, and it certainly doesn't mean that the parish council would merely support development within the boundary. But I'll come back to the Chichester case later on. As for subparagraph B, they do say that proposals within the settlement boundary will be supported, but that has to be read together with the conclusion in paragraph A. Then going back to what the deputy judge says about it, he says that the policy defines the boundary of the area within which new development is expected to be focused. Within that defined area, new development will in principle be supported. But as he says, and I do rely on this, there's no suggestion in the terms of either of those paragraphs that new development proposed on land situated outside that defined settlement boundary enjoys support under the spatial strategy of the neighbourhood plan. Again, I submit that that interpretation is correct. Going on to subparagraph C of policy 1, my lord, there are certain criteria set out there in sub-policy C. Don't read those out. And in any event, what the learned deputy judge says is paragraph C, or nor does paragraph C of policy 1, concerned specifically with new housing proposals, suggest that such development is likely to be supported on the site which lies outside the defined settlement boundary. Stated expectation that such proposals should meet the evidence-based needs of the Thurston neighbourhood area in accordance with policy 2. Just for the court's notes, policy 2 is at page 110 of the bundle. I might go to that in a moment. I won't take up time at the just for the second. In accordance with policy 2, it is, in the learned deputy judge's view, clearly concerned with the qualitative aspects of new housing, mix and tenure, etc. And what he says in relation to that is that expectation is to be understood as indicative of any broadening of the locational focus clearly articulated in paragraph A of the policy. So it's all coming back to paragraph A. Paragraph C doesn't treat new housing proposals, in contrast to other development, as under paragraph B, as worthy of support on a site that lies outside the defined settlement boundary. On the contrary, the fact that the location of new housing generally is to be governed by the spatial strategy identified in paragraphs A and B is evident from the exceptional treatment of development proposals to meet specialist and care needs under paragraph D. And I'll ask the court to go to that. That's back on page 105. And we look at that. That's an exceptions policy, to put it that way, my lord. Subparagraph D of policy 1, development proposals to be specialist housing needs, housing and care needs on sites that are outside the development boundary will be permitted where it can be demonstrated that no available and deliverable site exists within the settlement boundary. So if there's any shade of meaning to be implied into the word focused in subparagraph A of policy 1, my lord, that's the answer here, because it's saying, well, the substance of development, the first and 5, which the court has heard about, that's the development which will be focused within the boundary. But if you're an exception with paragraph D, in those exceptional circumstances, you can be located outside the boundary. So that's why it says focus. Finishing off on paragraph 64, what the learned deputy judge says is such specialist housing proposals may be permitted on sites outside the defined settlement boundary, but only where it's been shown that there's no available and deliverable site for proposed specialist housing within that defined boundary. Paragraph D, policy 1, seems to me, that's the deputy judge speaking, to reinforce the correctness of the interpretation, but read as a whole, policy 1 expects proposals for new housing development generally to be located within the defined boundary and gives no support to the development of new housing other than for specialist and care needs on sites that lie outside the defined boundary.
But was the question whether the neighbourhood plan supported development outside the settlement boundary, or was it whether it prevented development outside?
The question, my lord, was altogether that it prevented, it precluded development outside the settlement.
So the fact that it gave no support to development outside the settlement boundary doesn't really answer the question.
Well, it does, to the extent that this is one of the obverse cases, like the Canterbury case, and the court hasn't been taken to that, but obviously I need to do so if your lordship hasn't taken that point away from the authorities. It's cases, yes, there are cases such as Chichester, where they talk about supporting development proposals within the boundary, but that's just, shortly put, supporting within is not the same as focusing within, which means that that's where development is supposed to be put, my lord. And so the Canterbury case is one of the ones which my learned friend Mr Tucker would describe as an obverse case, where there were cases which provided where development was to go, and the question arose, well, does that allow for development outside the boundary? No, it didn't, and that's the class of case which the Thurston plan is within. If it helps to take the lordship to Canterbury straight away, I will do. Sometimes called Gladman, sometimes called Canterbury. Called Gladman because Gladman appealed it to the Court of Appeal. But actually, yes, in our bundle, those of the court with tabs, it's tab 4, but it's page 66 of the bundle, Canterbury City Council and Secretary of State. Decision of the Court of Appeal. Main judgment given by Lord Justice Lindblom. And looking at the head note, my lord, at letter E on page 66, I allow the court to read that, but I'm homing in on the inspector's conclusion between D and E. Inspector appointed by the Secretary of State allowed the developer's appeal on the basis that the proposed development didn't conflict with one relevant policy on residential development in villages, etc. Allowed planning permission, and Canterbury City Council challenged it. They were successful at first instance and appealed it to the Court of Appeal. And the debate emerges from the discussion of Mr. Justice Dove's decision in the court below. That's at paragraphs 23 and following of the report. And it begins at paragraph 23, where it says, Mr. Justice Dove's understanding of policy H1 and H9 of the adopted plan was that they identified the locations where housing development would be acceptable, and by necessary implication where it would not. And if one flicks back, policy H1 is at page 70 in the bundle. Within paragraph 8 of the report, if your lordship has that, I put it page numbered 70, paragraph 8. And I've got it just below my hole punch on that page, page 70, policy H1 stated. County Council will permit residential development on sites. And policy H9, that's on page 72, letter C.
Sorry, which page was that?
Page 72, my lady, letter C.
Thank you.
Save policy H9 stated, planning permission for new residential development in excess of minor development on previously developed sites within villages will only be granted, etc. And that's what led to the learned judge's conclusion at first instance that identifying sites where development would be acceptable, but therefore by necessary implication where it was not, its outside settlements wasn't acceptable. And so it follows through in the judgment, and Mr. Justice Dove's decision was upheld. And yes, my highlights on paragraph 31 on page 79. Ms. Tafur, who appeared for the City Council, both at first instance and in the Court of Appeal, she submitted at the time of the inspector's decision, H1 and H9 belong to a comprehensive local plan strategy for housing in the City Council's area, which, as she put it, contained a spatial division for the delivery of housing and policies to deliver that vision. Strategy didn't merely include specific allocations, etc. It established in explicit terms a clear and complete hierarchy of locations. So again, by implication, if you weren't within that spatial vision, you were without it, and there was no support for your, development. And that's why, in my respectful submission, even if the learned deputy judge expressed himself in terms of parts of the policy one not lending support for development, actually it's precluding development. Yes, that emerges from paragraph 35 of the report. That's the holding on page 81. Paragraph 35, policies themselves were perfectly clear. I hope that helps, my lord, to pick up that point at that stage. But that's why I say no support in the learned deputy judge's judgment means development precluded.
Yeah.
Was to be taken to mean that. And just before we leave Canterbury, my lord, because it helps, because it's one of the principles, but to see it in black and white, if I can ask the court to dot back to page 76, please. We've sidelined paragraphs 21 and 22, the principles to be applied, but I'm going to mention this when I come back to 38.6 later, and it's in the middle of paragraph 21 at letter D. And it says, if the section 38.6 duty is to be performed properly, the decision maker must identify and understand the relevant policies and must establish whether or not the proposals accord with the plan read as a whole. Of course, it goes on to say that one looks at the plan read as a whole, but in my respectful submission, what happened here, the legal error which the learned deputy judge below found and which the council committed was, one, not to perform the section 38.6 duty properly because they didn't understand and identify all the relevant policies, because in effect they excluded policy 1 because they said there was no conflict with it. They excluded it from consideration, and so their undertaking of the section 38.6 duty was not performed properly.
But they did say in paragraph 4.1 of the conclusions that there was a conflict with the development plan as a whole.
Yes, they did, my lord, and straining not to use the expression, that's the wrong part of the development plan, say, my lord, but there is a material difference between saying we're contrary to the development plan as a whole, so it doesn't matter which bits of it we're contrary to. If they had focused on the spatial vision, to use the phrase from Canterbury, that development had to be focused, concentrated, confined within the settlement boundary, then they would have had to come up with different reasons for their decision. It's not simply, oh, we've got to look at material considerations.
I'm not sure I follow that, because in this case, and one's not dealing with this in the abstract, in this case, as I understand it, certainly this is the way Mr Tucker puts his submission, what is clear is that the policies in the development plan as a whole, which this proposed development breached, were in particular policy CS2 and H7 in the adopted local plan. And to paraphrase, Mr Tucker says, well, they made clear that development of this kind should not be permitted in the countryside. So the committee were told that's the breach. As things stand, and ignoring for the moment the emerging local plan, as things stand, the current development plan does preclude this development in this site. So why is that not saying in substance what you wanted them to hear?
Because, my lord, and yes, I accept that policy 4.1 says that, but it is expressly confined to policy CS2, which your lordship mentioned, and H7.
Yes.
Those policies, members had been told, were out of date. So in effect, they were ones which could safely not be relied on at that stage. And again, avoiding the temptation to construe, heaven help us, the officer's report like a contract or a statute. Nonetheless, it's apparent from the debate. It involves dotting about a bit, but since your lordship has asked the question, I will do it. In the officer's report, which is tab 8, we've got, yes, one of the references to out of date is page 160 at tab 8. There's another one at 159, which my learned friend, Mr Tucker mentioned, so if I run up to that by identifying both pages, if your lordship has that tab 8159, I've got the first reference by the top hole punch. Number of policies in the plan have now been held to be out of date as a result of recent planning appeal decisions on inspectors declaring them to be inconsistent with the NPPF. And I think my learned friend Mr Cosgrove told us, because that must have been at the time when the council couldn't demonstrate a 5 years housing supply, so they couldn't rely on those policies. They found to be out of date. On this basis, and then it goes straight in to tilted balance, my lord. Next reference over the page is, again by the hole punch, 5 year housing supply. And I do emphasise this because it's relevant to a point I make later. The council is currently able to demonstrate that it has a 5 years housing supply. So actually, one of the critical factors on the basis of which the tilted balance is normally invoked isn't present here in the deliberations. But the council say this in the next sentence. However, as above, the council's housing policies, CS2 and H7, and CS2 was the one your lordship had specifically in mind in the question you asked me, those are out of date, etc. It goes on to say council's current position, it makes reference to housing policies. But it's the point being, my lord, at the heart of this report, albeit that it seeks to sum things up at the end by saying that, the development is in conflict with the plan as a whole. Nevertheless, the balance would have been different.
Well, the officer also says at paragraph 3.10.3 on page 224 that the neighbourhood plan fails to satisfy para 14b of the NPPF. So you can't rely on the neighbourhood plan to resist sustainable development outside the defined boundary for reasons previously discussed.
Yeah. Well, my lord, I said I was going to come briefly to ground 2 in due course, and actually that raises the significance of ground 3, which my learned friend Mr Cosgrove hasn't dealt with on the basis that everything follows from the construction of policy 1. But actually, what the learned deputy judge does say at paragraph 1991 of his judgment is he doesn't agree that the council couldn't rely, that the parish council could not rely, too many negatives, on their neighbourhood plan because of a perceived failure on paragraph B of paragraph 14. Sorry, I'll seek to put that more clearly, my lord. Going back to 3.10.3 on this page here, what the judge, what the officer tells to members is that members are advised that the tilted balance described in paragraph 11 is triggered by the fact that some of the relevant adopted policies are out of date. So that's looking back at CS2 and H7 again. And the fact, he says, that the Thurston neighbourhood plan fails to satisfy the requirement contained in 14b of the NPPF. And if the court has to hand the extract of the NPPF which was handed up, that's got paragraph 14 on it. Second page of that extract. What the officer is telling the committee is that the neighbourhood plan in effect falls down because it doesn't contain policies and allocations to meet its identified housing requirement. But again, that point was found against them by the deputy judge. In paragraph 91 of the judgment.
Yes, well, can I just ask you about that paragraph, because I don't quite understand it. What the judge says about 8 or 9 lines down, paragraph 91, is a question raised by paragraph 14b of the NPPF, is whether the neighbourhood plan has made adequate provision for the housing requirement that was identified for the purposes of its preparation. Why is it tied to the housing need at that date rather than the housing need which is identified when the application for planning permission is made? Why don't you
It's
understand
because
that?
that was what was available to the parish council.
Yes, well then it was in date when it was made, but it becomes out of date because the housing need has changed. That's how it becomes
yes,
out of
but
date.
that, in my respectful submission, is what paragraph 14b tells one. The neighbourhood plan contains policies and allocations to meet its identified housing requirement. It was the housing requirement identified for that neighbourhood plan. So that's why the learned deputy judge said in the paragraph, in the sentence your lordship has highlighted, that it was identified for the purposes of its preparation. Forgive me a moment. And, my lord, and I'm grateful for that reminder, but I was going to make a different point first, and I'll come back to what I've just been reminded of. The neighbourhood plan was made, that's the expression used in the statute for its formal statutory adoption, in October 2019. Mm-hmm. That post-dated by a very short margin the publication of what was just the consultation draft of the emerging local plan. That consultation draft was published only in July 2019. So a lot of the process of the neighbourhood plan had been proceeded through at that point, and then it was made on October 2019. But the material on which it was based was the material which included the Thurston 5, and there was no other competing requirement to be included within it. It met its housing requirement. And I keep telling your lordship that the plan was made in October 2019, and again under the statutory processes, it was made by my learned friend Mr Cosgrove's client, Mid Suffolk District Council, and they did not say, hold on a minute, the figures you've got in there for housing don't meet whatever the housing requirement is. There was no challenge to that. And so the neighbourhood plan did meet its housing requirement, and therefore, as the learned deputy judge concluded in paragraph 91, that's why my learned friend Mr Cosgrove takes exception to it, in his ground 3. But that's why the learned deputy judge concluded that another aspect of failing on behalf of the council as decision maker was that it hadn't compensated for its perceived application of the tilted balance by saying, no, hang on a sec, all sub-paragraphs of paragraph 14 are satisfied with the consequence, as it says in paragraph 14. It says that it displaces the tilted balance. It says this in situations where the presumption of paragraph 11d, the tilted balance, applies to applications involving the provision of housing. The adverse impact of allowing development that conflicts with the neighbourhood plan is likely significantly and demonstrably to outweigh the benefits provided the following apply. So tilted balance says you only refuse.
If the identified housing requirement changes after the making of the neighbourhood plan, broadly speaking, that's to be ignored. So
Well,
if there's some new marvellous employment opportunity opens up nearby, leading to much increased demand for housing, that's just too bad.
Well, my lord, it's simply, it goes to how the factors are balanced, my lord. And that's why I jibbed at the question put to me by my Lord Justice Singh about whether, well, isn't that an end to the matter if the council say, first of all, well, it's contrary to the plan, therefore we're into material considerations. This is all about the balance of the considerations here. So on my lord's example of an enormous employment opportunity, yes, that might come in to counterbalance the presumption or counter-presumption in paragraph 14 here, but it doesn't stop that presumption applying. Because, again, and never forgetting this, my lord, the parish council doesn't maintain its challenge at first instance of prejudice to the local plan process by allowing this site forward at this stage before the proper disposition of housing around the district has been settled on conclusively by the examining inspectors. That's not pursued, but there is the important point here about primacy of development plans, my lord. And again, there's all the guidance about how emerging plans are entitled to increasing weight the further they get through the adoption process. But here, my lord, what we have is a statutorily made neighbourhood plan, which is a section 38.6 plan. It's part of the statutory development plan, and it's also entitled to the statutory guidance, sorry, the statutory guidance, don't cancel the word statutory, it's entitled to the benefit of government guidance, again in paragraph 12 of the NPPF in this clip, which the court has been given. It says this, paragraph 12, the presumption in favour of sustainable development doesn't change the statutory status of development plan as a starting point for decision making. Where a planning application conflicts with an up-to-date development plan, it says this, including any neighbourhood plans that form part of the development plan, planning permission should not usually be granted. So again, I hope that's an answer to my Lord Justice Lewison's question. It also goes back as part of the answer to my Lord Justice Singh's question.
So essentially your answer, I think, to my Lord is it's not simply a question, does the application conflict with the development plan taken as a whole? It's to what extent does it conflict with the development plan taken as a whole?
And which parts of it?
Yeah.
Because again, we're not here in a case like Wyatt, my lord, and my Lord Justice Singh has raised the point again about how development plans can include policies which pull in different directions. In this one, there was no pulling at all in relation to policy one. There was tension, which in my respectful submission, and not being too disparaging about it, but I would submit it is lip service merely. The way the exercise should have been performed properly was to recognise the conflict with that policy. That would have changed the rules of the game, the positioning of the goalposts, whichever cliche I resort to express it. But it changes how the decision-making process would have been approached, and therefore necessarily would have affected its outcome.
Yeah.
Oh, and I'm sorry, I mentioned Wyatt, and I'm very grateful to my solicitor for drawing this to my attention when Lord Justice Singh made the point. Paragraph 98 of Wyatt, it's another useful example of the application of the policies, but paragraph 98 of Wyatt makes the point that there was no issue of policy interpretation for the court to resolve in Wyatt. The meaning and effect, the relevant policies of the development plan were uncontentious. In this case, the proper construction of policy one is at the heart of the case, and yes, as we've witnessed, the proper construction of it is contentious.
Yeah.
So, my lord, yes, I'd taken the court to the learned deputy judge's judgment, still on paragraph 64 at page 62.
I think you've taken us right through that.
I think I've taken you right through that, my lord. I'll speed up in relation to that, but I am going back to cover the learned deputy judge's important conclusions, because having looked in paragraph 64 at the plain words of policy 1, he then tests that against its context. And this is why I keep saying the learned deputy judge did what he was supposed to do according to the canons of construction imposed by the relevant case law. So he then, yes, he says in 65, necessary to consider whether the plan read as a whole reveals a more nuanced approach. It says, 66, case for the more nuanced approach. It is founded on 41, paragraphs 4.1 and 4.6. Now, well, heeding your lordship's slight warning, I won't read all the way through paragraph 67 at this stage, but commend it to the court, and in any event seek to pick out the key points emerging from it on the text of the neighbourhood plan. So going in that to its page, it's tab 7, page 103. And it's simply, again, the court has been taken through this, so I don't wish to labour it, but highlighting these specific passages, my lord, 4.2, 4 or 5 lines up from the bottom. For the parish council, I do rely on what the plan says here. It says it's not expected that significant additional growth will need to be planned for to support the emerging local plan. It's been explained to the court that the position of the parish council was in effect that after the permissions granted for the Thurston 5 developments, which totaled more than 1,000 dwellings, enough was enough.
Oh, it was 650.
No, my lord, it was...
Isn't that what the officer said? Oh, the shortfall.
Yes, so the shortfall was 650.
Yeah.
The competing figure is 1,400 and something, which is what comes from the JLP, the Joint Local Plan. No, my lord, apples and pears a bit. There's another figure of 1,000, and 1,000 is the total of the number of dwellings which were approved under the Thurston 5 permissions. If, while we've got the neighbourhood plan open, it is page 149, which we've looked at.
Yeah.
And one can see the built-up area of Thurston. It's A, B, C, D, E. They are the Thurston 5.
Yeah.
And so that's why the council is saying, in effect, enough is enough. And so we're drawing our settlement boundary around these. And that's it. And I'm going to come back in 2 seconds to the point about looking ahead to what the joint local plan will do about distribution of development. Again, it goes back to the parish council's position that policy 1 is a preclusion of development outside the settlement boundary. And yes, it's just the conclusion on 4.5. General approach in the Thurston neighbourhood plan is that growth will be focused in the sites on the sites with planning permission, which are located within them, and on small scale infill within. But then I've also mentioned there's 1D, which is exceptional developments outside. And 2 more points to pick up on the learned deputy judge's discussion in paragraph 67 and following. And it takes one back to page 77 within tab 7, still in the neighbourhood plan. I'm sorry, the court has been taken to this before, but there's an additional reference I would wish to pick up, but just to run up to it by highlighting paragraph 1.2, again, principal purpose of the neighbourhood plans to guide development within the parish. Skipping to 1.6, which the learned deputy judge refers to, Mid Suffolk District, along with Baber, currently preparing a joint local plan to cover the area of both authorities. First consultation on options was held in late 17. Yes, with the consultation draft due in December 2018 to Jan 19. A publication draft of the plan is due in spring 2019. Again, it says with an anticipated adoption date of winter 2019-2020. I'll come back to this point in due course, my lord, but we're winter or approaching winter 2022, and the plan is no further ahead. There's been an examination which was stalled, but we're no nearer to getting a statutory joint local plan, and as I'll show the court when I come back to the parish council's representations on the plan, the issue of housing numbers and distribution is still very much in dispute, but that's still ahead of them. And the passage I was going to pick up, which hasn't been put before the court before, but it's on page 80, 115, sorry, paragraph 1.15. I'm sorry, I skipped ahead while talking about the stage. On paragraph 77, 1.6 finish off by saying the pre-submission neighbourhood plan has sought to reflect as far as possible the emerging joint plan, but given its early stage of preparation, that's been limited. That's what it says, but albeit when it was adopted, no exception was taken to its terms by the district council, even though they were preparing their plan. Jumping ahead now to what is acknowledged.
Just pause a moment. When this consultation was held, was the site we are concerned with already allocated for development?
No, it wasn't, my lord, because it only emerged in the consultation draft, which I told your lordship a moment ago. I'll get the date.
That postdates the neighbourhood plan, does it?
Well, from memory, my lord, the consultation draft with the first draft allocation first came into existence in July 2019.
Right.
And that was while the neighbourhood plan process was already in train.
Told us it was October 19, is that right?
Yes, it was concluded in October 19.
So is that for the referendum or something
But
like that?
yeah, the referendum was September 2019.
So it's still after the allocation of this site?
Well, it's the proposed allocation. It is first. The referendum was after the idea of an allocation for consultation had first seen the light of day. Right. And I do emphasise that.
So when paragraph 1.6, it's the pre-submission neighbourhood plan sought to reflect the emerging local plan. But the one,
I expect
the one that was voted on didn't.
Forgive me, my lord?
The one that was voted on didn't reflect the emerging local plan.
Well, it did to the limited extent referred to, because one, there would have been an issues and options document which had been published previously. I presume the allocation of the Bayton Road site wasn't included within that, because I don't recall being told there was any objection to it. But nevertheless, and reminding your lordship that the seeking to use a word, the ultimate authorisation of this plan, it's made by the district council. It goes through them for checking, for forgive me? For assurance, for vetting. It's something which they're in a very strong position to say, no, something is going wrong here, if there's something significant they object to at the date when it's being published. So, and my learned friend Mr Tucker made a point about, planning decisions and plans are always coming forward and things take time, and how you have to put a marker down, you have to make a decision at a certain point in time in relation to a plan, having regard to whatever state it may have reached at that decision-making moment. But the neighbourhood plan, and I use the expression primacy of development plan, the neighbourhood plan got in first. It is the latest to be adopted, and under section 38(5) of the Planning and Compulsory Purchase Act of 2004, it has priority over any other development plan, having been the latest adopted in time. So to that extent, it trumps the core strategy. It trumps the previous version of the local plan. And it goes back to the point I was making by reference to paragraph 12 of the NPPF, that one can expect development applications for planning permission for development to be refused if they're contrary to plans.
Did you say subsection 5?
38(5).
Do we have the text in the bundle?
We do not, my lord, but it's simply an urging.
Perhaps we ought to have
the
full text of the whole of section 38.
Yes, my lord. And seeing the way I'm going, I can't promise to be finished before the short adjournment, so I'll ensure that that's supplied to your lordship. And so that's the position that was reached when 1.6 was drafted. I note, my lord, because it still refers to the Thurston pre-submission neighbourhood plan. Presumably someone should have, with a blue pencil, should have taken out the words pre-submission neighbourhood plan, because when it was made, those words were OTOs, or they'd been overtaken by events. Because it's now the made plan. Where I was going, my lord, is to this passage on page 80, 1.15. Thurston Parish Council, or the neighbourhood, as the neighbourhood plan authority, will be responsible for maintaining and periodically revisiting the plan to ensure relevance and to monitor delivery. The ongoing development of the joint local plan, which is still out there, it's emerging, means that the neighbourhood plan is likely to be reviewed within 5 years of being made. So that's what the neighbourhood plan has to say about the JLP, the joint local plan. It knows it's running along, not in tandem, not in the context of Chichester, which I shall come back to, where it was said that aspects of the housing strategy were purposely split between the parallel plans. The neighbourhood plan here is the front runner, and to extend the image, the joint local plan is very much running behind. Yeah. And there's no dispute about this in point of fact. One of the matters which the learned deputy judge had to deal with was an application by myself on behalf of the parish council to introduce late evidence as to the progress of the examination of the local plan. But be that as it may, matters have not progressed any further. Yeah. It's still in the future the resumption of any examination hearings for the neighbourhood planners, and I keep promising to do, and I shall do it, but try and do it in the order of the submissions as I'd originally planned them, rather than simply picking up a point here and a point here, there as I go along. But it's the foundation of the parish council submissions that actually, when the local plan process resumes, again, as much development as is proposed to be located around, outside the settlement boundaries of Thurston, is simply not acceptable, looking at the balance and distribution of potential for housing across the district as a whole.
And it's that line of thought which effectively led the judge to conclude at 69 that it was too early.
Yes.
He jumped the gun.
Yes, my lord.
Yeah.
Yeah. Where he looks. But that's having said that paragraph 68, that he can see the benefits to a local planning authority that's promoting a plan of saying, well, look, this is one of our key centre sites. Okay, it's outside. Let us permit it. But again, those are all, as it were, other material considerations under section 38(6).
Yes.
It's not. It doesn't get you back to the starting point, which again, under the case law on interpretation of plans, the development plan is the starting point, and under the NPPF, it's the starting point. So, in order to decide whether a development is in conflict with the development plan or not, one needs to have the correct starting point. One needs to have identified the policies which are, well, in the words of the Wavendon case, are the most important for deciding the application. So if you've excluded one by saying it doesn't apply, that's where you fall down on doing section 38(6).
I noticed that proposition in that case. Is there any authority at the level of this court or higher which has made that point?
Wavendon has been approved in Paul Newman. The case is called Paul Newman Homes. And I'll chase that down, and again, having an eye on the time, perhaps bring a copy of that back with you.
That would be helpful, speaking for myself.
Have we reached a natural break, Mr. Lewis?
I was just looking at my note, my lord, and yes, we have. Thank you very much.
Thank you. 2 o'clock.